So the second panel is really on the legal aspects of self-driving science. I think it ties up really well with what we've discussed, operationally how this works, and on the legal framework. So as a little bit of an intro, when a scientist makes a discovery, we know exactly who to credit, right? When we make a mistake, we know who's responsible for the mistake. Hopefully nothing happens to that person. But when the system, when the thing that is designing and running these experiments is autonomous, I think these things can get murky. And I think science is not waiting to catch up. The law needs to catch up to where we are. So I think, well, here we got 3 people that who deal this in practice, and I wanted to have this panel to discuss this, also open to the public, to the audience with any questions. As an intro, Aaron Weaver is the Chief Commercial Officer at Molecule. He leads commercial strategy, the tokenized IP model. Before Molecule, he was a senior partner at Payer Investments focused on biotech, longevity, and mental health. Board seats at Rejuveron and Alto Neurosciences. Lawyer, financier, biotech investor. I hope that's okay. Jose Pinto here is a lawyer and counsel to Molecule, General Counsel for Bio Protocol and VitaDAO. Formerly General Counsel and a board member at Aragon. He works mainly on regulatory matters, token issuance, DAOs, AI tools. So he's one actually structuring ownership and compliance for on-chain science before rules really exist. Martin Carlson, I already gave an intro, so a short one. He's been in applied AI for over a decade, and he spent the last 4 years at the intersection of open source, AI science, and programmatic funding, and now he leads applied AI at Molecule and PepAI. Jose, I want to start with you. I think a lot of people are unsure these days if AI can, for example, file a patent. The US, Europe, China all require a human inventor, but the US recently made it easier to patent what an AI helped created, as long as a person signs off as the inventor. So when an agent does the real work and the human just puts the name, who actually owns that? And does it hold up?
So, well, until now, and we have to understand, like, on the traditional framework that we have to patent science, one of the main criteria was exactly the inventorship, which is the human representation and visualization of a solution for something that I can present on paper, I can basically protect on a physical way and claim the rights, the ownership rights of that idea, of that solution that I create. Right now, as it stands, we still have that criteria as absolutely essential. So to your question, AI by itself cannot claim any type of rights, cannot file for any type of patent. What has been discussed right now is if somebody that is behind the design, the implementation, and the use of AI for such discovery will have the right to patent it in its own name. So that resolves, basically, it's how, you know, AI tooling has been framed within the existing legal scenario that we have. The second issue, which I think is important also to discuss, is we still need a legal entity or an individual, the legal personality, to claim the rights, to register the rights on their behalf. Why? Because it's on that legal agreement that you actually are able to license, to pass it on to somebody, to claim royalties, to sell the IP, and monetize your invention. So, I mean, there are some breakthrough solutions that some courts have been coming up with. I think right now, since 2018, basically this has been the main ruling on how to use AI as a tool, not as an autonomous entity that can actually file for a patent. So always requiring the human intervention and the human visualization behind it. I think with time, we will see that it will become more difficult to associate only one person or only one entity to one discovery, basically because it becomes really more difficult to control the databases in which the AIs are running, which brings other type of issues like IP infringements, data protection, all in on. But I mean, right now this is where we are. I mean, it's still very traditional to this stage.
Sorry, I want to step in here and say something. It's probably an opportune moment for almost a reconceptualization of intellectual property regimes. This question sort of extends much higher than beyond like just legal frameworks, because it's going to go to the heart of trade policy and overall economic competitiveness. We're really transitioning to a matter of intelligence. It's actually going to be driving innovation. There's obvious questions around about your ability to protect and actually enforce granted intellectual property. But a lot of the sort of, I would say, the creatorship in things of deep value is really going to like come through like artificial intelligence rails. Now, there's problems, significant problems with the existing IP frameworks, and there's never really been too much of an incentive to rethink through them, only with the exception when you have a very well-financed entity, and say I take Disney, for example, and this sort of just demonstrates how the original intellectual property laws for patents, copyright, et cetera, were developed in the early 1600s in the UK, so it was actually the statute of monopolies, like adoption, that sort of transpositional law effectively occurred in the early 1700s into the US, but Disney had to lobby the government because all their IP was effectively expiring because it's life of the author plus 50 years. That's like a $200 billion company that just like writes down to like nothing at all. And so the US actually lobbied WIPO, which is the World Intellectual Property Organization, to actually extend that. But the broader based issue that you're going to have here is that it becomes very much a policy-based discussion in the way that intellectual property be granted in these things, and that's actually going to be really at the forefront of sort of economic growth from my perspective. And so territories that can think through this in a rather good way, and obviously there is like, the PCT and all these other sort of, I'd say like international, supranational organizations and treaties that sort of harmonize and bring this all together. But, like at the forefront of that is there is a much more pertinent question for government about what they want to do about it. And actually, the US and China have been sparring a little bit on opposing degrees of trade policy about co-inventorship for AI, for artificial intelligence in relation to patents. And so, that's a giant economic lever that policymakers can pull. But I can go deep into this, but yeah.
But great feedback, Aaron. And maybe while I have you here, I think it would be great to know how does Molecule actually capitalize on the fact that a lot of for instance, the drug development, it's compartmentalized into different areas where you have maybe the inventor, the funder, the CROs, the different AI tools, where it's important to show who owns what, and in some cases you can have problems of royalties or IP. How does Molecule is able through the on-chain rails, through the IP-NFT, able to capitalize and to solve some of these issues?
Yeah, thanks for that question, Rafa. So in respect of the conversation that we've been having all day around AI, we've been speaking about tooling. There is something at an infrastructure level that we examine within Molecule, which is really tooling for financial engagements or financial instrumentation. And it's probably an area that's not spoken about enough in respect of science. Like, we very much focus on advancing the science, but the science needs to push through relative market frameworks. It needs to go to stakeholders. I reiterate the point before that, just because it was done like 50 years ago doesn't really mean that we sort of need to adhere to what those standards are today, or at least not sort of, start asking the questions about whether things can be done differently. The on-chain provenance, the fractionalization great additive tools in respect to that. But like with the, the development of, and actually, I mean, programmatic payments, a significant move effectively in themselves, because, agents can't have a bank account, they can't have a credit card or anything of the sort. And so, and there's something nice about like code being law and knowing that you're going to have a natural enforcement of, or adherence to like whatever's, whatever is effectively being agreed. And I think you can start to see standardization in respect of like the way that a lot of these services effectively interact. But, like a lot of that also bears in mind too, and I think Michael Torres, if he's here, was sort of saying this before, is that like, a lot of these things do get bought by pharma. They're very mindful of like what is effectively occurring within the cap table and how things are requisitely capitalized, at what levels and things like that. And so, like a lot of that can be created in like with the mindset that, there'll be other industry participants that don't have such a, I would say, an adaptable mindset on the way that this evolves. But in summary, tokenization, so basically some of the fractionalization, talking about like inventor attribution, you've got all the logs. I mean, algorithmically, you can run back who's made what contribution, tracing it back to the relevant patent claims or like delivery within services, et cetera. So like, in short, it's just having all the things there to actually develop the tools that are really, really needed.
And I think back to the programmatic funding, if I can ask a question to Martin now, because we've been discussing this constantly on PepAI. And what does that open up when an agent can use that? When can pay for its own when an agent can pay for its own experiments? When it can hire the lab on its own? Just what gets unlocked versus what gets risky? And how can agents start maybe participating as economic actors?
Yeah, so I think dovetailing to what Aaron was outlining there, I think the starting point for answering that is that this new, for me, the fundamental thing is that, as Aaron mentioned, in the AI bio space, you talk a lot about like how AI accelerates science. The jurisdictional compliance of those systems isn't really like the fun thing that people talk about. And so there's what I'd say, like what's really great about being in this collaborative experience is that we've been really talking about that from the beginning. So that's where like Molecules On-Chain Labs actually gives you a programmatic environment that can move at the pace of the AI in such a way that you have like this substrate where you can use the traces that are being generated by the AI system and like basically publish those to the lab in such a way that you have this verified container of everything that was done that is programmatically compatible. And so with that substrate, it's really like one of the things I'm most excited about is that it also solves for this question. Because what it means is that you basically can have an agentic system that can be tied to then a corporate entity, and you can even imbue the agentic system with an understanding of the regulation so that it could be like, I need more human input. Which is kind of, from a technologist perspective, kind of paradoxical, but that aside, I think what's really exciting here is that you actually have the primitives to create a truly mature entire package for this type of autonomous system where there are answers to those questions. And also just to mention, I think there's been, I think, some examples of how some earlier stage startups, if they get, they talk about all the AI they're using and so on, you might have some bigger players actually, challenge them in the courts so that they don't even get out of the science side. So here you have something that you can plug into from day one to have a programmatic audit trail. So I think that's like a key artifact that is now available to these systems that helps answer those questions of like, if you're gonna have programmatic funding, how do you do that in a compliant way and how do you show that you've thought through it? And that's what I think we're perfectly at the intersection of that, and it's really how, the on-chain component and the AI comes together then with also the funding in a way that actually stands up, essentially.
Back to Jose. Thank you, Martin. So Jose, in this decentralized infrastructure, how is liability and risk distributed when you have DAOs, tokens, autonomous agents doing science?
Well, liability is always centralized, right? So there's no such thing as like fully decentralization. When things go to court, basically what the judge will try to assess is who is the human in the loop that they can chase in order to ask for some sort of liability. So that happens in DAOs, that happens, any type of use of technology. There's like a sitting duck somewhere, somebody that kind of owns the trademark, or just made a post on X or something like that, that can be said, well, this guy actually has some sort of involvement, because there's no full decentralization as we know. It's just how the court system works. They will chase somebody. It's impossible to sue everybody. They will sue, on civil claims, people try to sue as much people as they can, but it ends up being always the same guys controlling the protocol or controlling anything. So, of course, throughout the years, we're assisting as an increased decentralization of how these protocols work, how IP is being governed, how IP is also being registered, also on traditional ways. But one thing I wanted to add, and I think it's also important for people to understand what we're doing at Molecule, is that as it stands, and this is a sentiment that has been also from inception from Molecule, is that the current legal framework, the IP legal framework, is blocking innovation, is blocking scientific research. And the fact that the intersection with blockchain, with AI, allows that there is some sort of visibility, a much wider visibility of what has been achieved. It's also important that people can govern, people can actually claim the ownership of their discoveries, of their achievements, for everybody to use also in the future in a compliant and transparent way. And it's not the blockage system that we have been witnessing on the traditional legal framework on the protection of IP rights. It's more of the power of the community-driven management and governance of IP that I think matters more for breakthrough on discovery.
Maybe just a question to whomever wants to take it, maybe a little bit controversial, maybe doesn't make much sense after what we've discussed, but does the law have to catch up to science? If we continuously iterate on these autonomous loops, maybe it gets a bit blurry who is the human that is in the loop or the group of humans after so many iterations and so many groups collaborating. Does the law catch up, or does agentic science run into some kind of gray zone? Who wants to take it? I'm curious.
I think just as a natural function, law runs as a reactive function. You can't prescriptively legislate for every interaction and everything that's effectively going to occur. And I'm talking outside of science. We've sort of also moved a little bit to a political landscape where grievance at any significant levels starts to determine what gets addressed at a legislative means. There's this sort of widening cliff between people who are determining policy or legislators and technology direction, and what that really fundamentally means is that anyone who has lawmaking power just struggles to understand tech in any meaningful way, and it's just going to be increasingly really, really hard for them to get ahead of anything that's going on. It's just going to be a question of what is necessary for a degree of political appeasement. And now I'll sort of switch to talking about economics. There's this overall imperative for almost every country in the world to be just driving hard at innovation. It literally is an arms race. So, I think that there'll be this sort of mild undercurrent of entrepreneurs just being, proactively sort of pushed or supported to just innovate as hard and as fast as they can, despite the fact that the law is just sort of not there for them.
Let me just something. So, innovation comes always first, law comes after. That's how things work. That doesn't mean that judges, courts don't find a way to pick up what is happening and trying to subsume it in the existing frameworks. And that's an error. So that's basically what is the problem. Currently, the problem with AI tooling, collaborative DAOs, for instance. I've been struggling for the last decade probably to explain to a judge what a DAO is and how a DAO works. And for them, they just pick up on the existing frameworks and they call it like a general partnership, or this is a kind of a Einfachgesellschaft or something like that that exists for decades already. And so there's not like an appetite to understand on a futuristic vision how this could be like a future new type of entity that lives on chain or whatever. Same will happen with AI, same will happen with other type of toolings. But that's how innovation comes through. It's pushing the boundaries, and then probably 20 years, 30 years, 50 years later, somebody will come up and say, oh, probably we need to change the law because this is not coping. My perspective is always like the law is not an absolute blocker. Of course, we have compliance requirements, and of course, we have to navigate the legal system, but we always have to find our space, loopholes, perspectives of new interpretations, how the law works. I'm speaking now also about the new European AI Act on justification how you come to a certain decision based on AI tooling and so on. So we have already frameworks that allow us to push the boundaries a little bit forward. But to your question, of course, it's a gray zone. It will continue to be a gray zone, and it takes time to consolidate with different cases, with different discoveries, with different rulings, with different jurisprudence and studies that will be made on the applicability of these tools in practice to change the law in the future.
Yeah, makes sense.
Thank you so much, guys.